SJC-13039, Khris, Hovagimian, v. Concert Blue Hill LLC, and others.
Great. Good morning, council.
Morning.
We'll start with Attorney Holtzman.
Good morning, Chief Justice Budd, and may it please the court. My name is Paul Holtzman. I represent the plaintiff appellants. This case involves the automatic liability of an employer which chooses to impose a mandatory service charge on a banquet invoice and fails to remit the proceeds to its service employees. This conduct squarely violates the TIPS Act, under which, as Justice Gantz wrote in the De Fiore case, employers are, quote, barred from pocketing service charges. The fact that the legislature intended precisely this uncomplicated, strict liability has been consistently recognized by the appeals court and this court. As Justice Milkey,
Mr. Holtzman, could I ask you, Mr. Holtzman, about the safe harbor provision?
Yes, Your Honor.
So if you look at 152 AD, clearly when you're talking about a service charge, talks about remitting it to the wait staff if it's in a bill, invoice, or otherwise in a charge. But then you have another paragraph where you get to the safe harbor provision. Why do you say that the statute requires the safe harbor language to appear in the charge, invoice, or bill?
Your Honor, we actually take no position on the question of where the safe harbor language would appear, nor does the court need to reach that issue, because the safe harbor clause has no relevance when one of the three per se service charges is designated on the invoice.
No, but that's my question. Respectfully, that's my question. I understand, I'm looking at it right now. I understand that subsection D says if there's a service charge in a bill, invoice, or charge, that there's strict liability. I understand that argument, and I appreciate it. But then you have another paragraph, and that paragraph doesn't limit the safe harbor provision to the bill, charge, or invoice. Give me the
Correct, Your Honor, but it doesn't
statutory
limit-
interpretation that says safe harbor has no application if it's not in the bill, invoice, or charge.
That's not our position, Your Honor. Our position is that the safe harbor has no application because the statute says the safe harbor has to be language which is instead of a service charge. In fact, it says the designation required by the statute says is to inform the patron, quote, that the house or administrative fee, quote, does not represent a tip or service charge. So needless to say, it would make no sense where the fee itself is explicitly designated by the club as a service charge to have the safe harbor provision have any meaning or relevance to it. So it would be illogical to conclude that the employer could modify or void the per se or automatic liability of the label service charge, which they chose, by adding safe harbor language. More importantly, or equally important, the safe harbor provision relates to charges denominated administrative or house charges. No such charges appear.
I mean, I understand that argument, and that may very well be right. But the appellees and the appeals court at some point is saying, look, it's clear in the initial contract that that's what was going on. And if you even look at the final invoice and the divisions of the 10%, it's clear that's what's going on and that this is good enough for safe harbor. I think that ultimately, if you dig down, that's their position.
Understand, Your Honor, but there's a drastic difference between the contract and the invoice. The invoice makes no reference to an administrative charge or a house charge, nor does the banquet invoice, which breaks any connection between the contract and the invoices. Importantly, the very clause in the contract that the defendants rely on starts with the following language. It says that all charges are subject to change and will be confirmed within 30 days prior to the scheduled event. Now, what are those confirmed or actual charges that are identified prior to the event? The only such charges are gratuities and service charges. There's no reference to an administrative charge, no reference to an overhead charge. So the banquet event order form modifies the contract, specifies the actual charges, and for the first time places dollar signs in front of them and identifies the dollars that the patron is committing to pay. These record facts refute the contention of the decision below that the invoices do not impose new fees, but are mere summaries of some of the fees listed in the contract. To the contrary, the invoices impose the actual confirmed fees, and the contract itself anticipates that the actual fees will not be charged or calculated until the end of the event. The reason that happens is, of course, that these charges are calculated as a percentage of food and beverage purchases. No purchases have been made until the event is concluded. Therefore, there are no dollars against which to apply those percentages. So the only charges which are imposed are those that are imposed in the invoices. The contract is a pre-event document of the sort that Norell confirmed.
Isn't that silly though? I mean, I understand you may be right that the statute has this sort of strict liability on invoices, but that clearly wasn't the intention here. The employees got 10% and the club got 10%. And the appeals court clearly is right on a reality check that this was in. Are there any appellate cases in which the employees actually got a separate tip provision where you apply this strict liability rule? Because here they actually did get paid tips, right?
You're correct, Your Honor. They've got paid a 10% gratuity. The 10% service charge, however, was not paid to them.
Okay, but I want you to first answer the question. Are there any of these other appellate cases? Are there any appellate cases where employees actually did get tips as opposed to where there was a fight over who gets the fee?
So not an appellate case, but we have cited to you the Banks decision. You may have noticed from Judge Fahey dismisses this argument.
Yeah, but again, no appellate cases. So
the relevant appellate decisions here are Cooney and Bednark, which speak to the question of whether an accident or a mistake or a drifting off course by the employer can save them. And what they say is that the legislature chose a particular approach, an uncomplicated approach. As Cooney says, where the employer decides for whatever reason to use one of these three automatic liability charges and recognize this might catch up.
That's your argument, right? That's really your best argument, that if you screw up, the employee gets the benefit here, even if it was clearly not the intention to give the employee this money. Isn't that your argument?
Because Cooney says that the intention of the employer is wholly irrelevant.
Well, it's not just the employer, it's everybody's intention here. The employees understood the rule probably, the patrons understood the rule, the club understood the rule, but still somebody screwed up and used the word service charge at the end, right?
Right, Your Honor. In fact, Cooney, this is an a fortiori case compared to Cooney, because in Cooney, all of those things were true. The patrons were told, if they asked, well, who's this charge for? Oh, we're not giving this to the staff, we're keeping it. So the patrons knew it was not a gratuity. Likewise, the staff, according to Cooney, understood they were not getting it. The appeals court said, doesn't matter because this is a strict liability, and who controls the designation? The statute talks about the designation.
Well, is that right? Are you overreading Cooney? Was that really true that I understand when somebody pays a bill and it says service charge, you think you're giving it to the people servicing you. And it's unfair to sort of for the owner to take the money, but this is different. Did Cooney actually was Cooney, the facts of Cooney stated expressly that everyone thought this was going directly to them, including the patrons? They understood that the patrons understood what they were getting into?
Yes,
Where
Your Honor.
in Cooney does it say that?
Cooney facts include that the employers were not able to evade the liability there, even where they were telling patrons explicitly that the service charge on the invoice was not a gratuity. And I can point you to the language in Cooney.
Yeah, I've got Cooney in front of me. Where does it say that? Oh, don't worry about it. We can read it ourselves. So
both the patrons were told it was not a service charge, and the employees, Cooney says, understood that they were not going to get it. Nonetheless, what the Cooney Court says the legislature didn't want factual disputes, individual inquiries as to particular charges, the understanding of particular patrons, or the intent of the employers. Instead, they chose this, quote, uncomplicated approach of setting out 3 terms which trigger per se liability if you designate them on the
So
invoice.
in a sentence, Mr. Holtzman, your position is, in one sentence, that if in the invoice, the employer uses the word surcharge, that it's strict liability and that surcharge goes to the wait staff. Is that right?
Your Honor, I believe you meant service charge, perhaps. You said surcharge, I
Service
think.
charge. Yes, service
Yes.
charge.
Because the
That's your
statute
position,
defines
right?
service charge appears designated on the invoice by the employer that the proceeds are required to go to the employees, full stop, according to Cooney and
So then
DeFiore.
as far as the Bernard case and trying
sorry?
to figure, the Bernard case, BEDNARK, and that analysis about what, a reasonable customer would think that the term means, that in your position only applies when the term does not say gratuity, tip, or service charge.
That's correct, and that's strictly out of the statute, Your Honor. The statute defines
And-
2 categories,
and
the
so
first of which are these per
The
se
challenge
categories.
with that goes back to Justice Kafker's point, which is everybody can understand that the service charge isn't going to go to the wait staff, but the service charge still goes to the wait staff if the word service charge is used.
Well, that we believe is the fundamental error by the decision below. They've applied a reasonable understanding or reasonable expectation standard, which is inapplicable to the first half of the definition of service charge. Category 1 is any fee designated as a service charge, tip, or gratuity. That's what Bednark refers to as the automatic liability service charges. Then the definition continues, or second separate clause, a fee designated as something other than one of those 3, which is nonetheless a fee that a patron, quote, would reasonably expect to be given to service employees. That reasonable expectation standard has no applicability just from the structure of the statute, let alone Cooney, Bednark, DeFiore, and Meshna, when you have an automatic, when the employer has selected one of the 3 automatic clauses, tip, gratuity, or service charge. If you have a tip and a gratuity, obviously both of those have to go to the employee. The same with gratuity and a service charge. They are interchangeable terms under the statute.
Mr. Holtzman, is the sentence here relying on Cooney, the following? Northeastern never intended to, nor did it remit the proceeds from the service charge to the Chartwell's employees. Is that the sentence you're relying on? Because that's different from what we've got, where we have a negotiated understanding by, where we, and it's that, I mean, just because you don't intend to, if you keep it secret, that's a whole different story. Or is there something else in Cooney that you're relying on?
There is, Your Honor. There's the language where the Cooney employer, Northeastern, there informed patrons that the service charge was not going to the staff, which would be akin to what they're arguing here with a contract provision. And the decision was, regardless of that and regardless of the intent, there are 2 issues which are both deemed irrelevant by the Cooney court. The intent of the employer, which you just mentioned, but also the understanding of the patrons who were specifically informed this is not a gratuity. The court said, nonetheless, you have, whether intentionally or otherwise, doesn't matter, used one of the 3 designated automatic liability clauses. Liability attaches per se automatically. That's the structure selected by the statute. Now, Cooney said the employer there, like the club here, is asking for you to write something else into the statute. Say, well, not innocent employers shouldn't have to pay those over. And Cooney said, we're not entitled to add language where the legislature chose not to. The legislature drew a line, a bright line rule, no question about it. And the court said, we are not in a position to modify that. Even if it captures from time to time an innocent or haphazard labeling by an employer, the line is a bright line rule. It's an uncomplicated mandate that the TIP Act has been uniformly recognized to have by this court and the appeals court up until this decision. Simply put, the use of the per se liability language, tip, gratuity, or service charge, controls over any language in any pre-event documents. It makes the intent of the employer and the understanding of the patrons irrelevant, and it negates any reference elsewhere to safe harbor language, since such language is effective only where employers denominate a fee as something other than a tip, gratuity, or service charge. And here, the only charges imposed were a gratuity and a service charge. As a result, we submit that the decision below should be reversed as inconsistent with the plain language of the statute and the long settled precedent, and the matter be remanded to the Superior Court for entry of an order allowing plaintiff's motion for judgment on the pleadings.
Thank you very much. Okay. Attorney King.
Thank you, Your Honor. May it please the court, Paul King on behalf of the appellees. The plain language of the TIPS Act and the relevant case law tell us that the question before this court cannot be answered without considering the full context of the transaction at issue. In De Fiori, this court made an important observation about the TIPS Act. It expressly invites courts to rewrite and fit the statute's definitions based on the transaction that we're looking at. Also in De Fiori, this court confirmed that the legislative intent of the act, the very purpose for which it exists, is to cover the funds that the patron intends the waitstaff to receive. Here, it's the event contract that gives us both the full context as well as the controlling intent of the patrons. There is no basis in the statute for eliminating or removing the event contract from this equation. The event contract defined the terms for the transaction, including the agreed upon percentages in terms of the 10% portion that was going to be kept by the club as an overhead charge and the 10% tip or gratuity that was going to the waitstaff employees as a tip. In this context, there is no question about what that charge could be. In this context, that charge, regardless of how it's mentioned subsequent, cannot be a service charge, as that phrase is used within the act.
Mr. King, if I could interrupt you for a moment. So let's take your position in that 152A subsection D is not dispositive when they say bill, invoice, or charge, and you look at the entire transaction. The amicus brief, the Mass Employment Lawyers Association brief, says that if you then apply this reasonable belief standard, every time a service charge is added to the bill, you're going to need a trial to be able to resolve the credibility issues just to determine whether or not the staff gets the service charge. And you know who that's going to inure to the detriment of? The wait staff who can't afford to litigate against the deep pocket.
Sure, Your
Why
Honor.
isn't the amicus brief right?
Well, I disagree with the amicus brief's point, and the reason I do that is because, as Your Honors have pointed out, there are no cases interpreting this statute where a detailed contract that explains a disputed charge exists. And I would disagree that in every circumstance we would need a trial, because in some circumstances like this one, there could be a contract, and that contract is controlling. And in Massachusetts, we give effect to contract provisions. We enforce them regularly, and they are conclusive as to the signer's intent. So I would disagree that that problem would be created by an interpretation that agrees with the appellees in this case, because this case is very unique, Your Honor. So I believe that the amicus is creating an issue that would not come up when an employer or an invoicing entity is able at the beginning of an action to show, much like we did in this case, that, look, here's the contract. This wasn't just, a tip left on a piece of paper at the end of a meal. This was different.
Yeah, but so many wait staff, they live paycheck to paycheck. And even when it's not a pandemic, a lot of them are struggling. And all the employer needs to do is put the right language in the invoice. And isn't that why it's a strict liability statute?
Well, I think strict liability, and this is a phrase that my brother has relied on, I think strict liability does not mean we don't look at the context. And I would point, Your Honors, to some important parts in the statute. As De Fiori spent considerable time recognizing, the opening clause to the definitions section specifically says, unless a different meaning is required by the context or is specifically prescribed, the following words have the following meanings. Here, both of those triggers are present. Required by the context, clearly the contract is the context. But more so, the contract specifically prescribes what the charges in the transaction were. So strict liability cannot be something that can remove language from the statute. And I think another point on that point, Your Honor, is the introductory clause to the safe harbor language. Nothing in this section, the entire section, shall prohibit an employer from imposing on a patron any house or administrative fee in addition to or instead of a service charge. And I would draw Your Honor's attention to use of the phrase in addition to or instead of a service charge. That does not appear in the opening part of the definition for service charge. In that spot, the legislature specifically said a service charge is something that's assessed in lieu of a tip or a gratuity. And in de fiori, we said that that is all one definition. We said
So
that those are not
counsel,
separate things.
may I interrupt you for a minute? Just to clarify, when I look at the language of this, though, the invoice says tips, the way it's categorized, the categorization of it is charges, taxes, and then service charges and gratuities together. So it's one thing. Do you give meaning to the way the language is structured or the grammar of the invoice?
Yes, Your Honor, I think that's an excellent point. And I do think that those distinctions are critical when pulling this case outside of Cooney. Cooney and the magic words there were very different from the invoices here, even forgetting the event contract. Here, as Your Honor has pointed out, on the first invoice that follows the contract, the term used is service charges and gratuities. That tells you they're separate. They're not the same things. There would be no reason for having the phrase service charge and the symbol and if they meant gratuities. And then I think if we look at the last invoice, this becomes even more apparent. They're separated out into three separate categories under the heading of service and tax charges. So again, we do not have the phrase service charge in isolation. And again, we have a contract, or excuse me, an invoice that spells out distinct charges. Therefore, one cannot be the same as the other. They're distinct, and that's consistent with the event contract. And I think a critical point,
But they're linked, they're so linked together in
They
the
are
way
linked.
it's structured.
yes,
And there's no language in here about an administrative service fee or it's just a general service fee. So what are we to make of that?
I think that's where the legislature instructed the court to look at the context, which is the contract. I think we cannot remove that. I think doing that reads out a number of provisions from the language of the statute. And on an important point on that, I would like to draw the court's attention to the safe harbor language. As Your Honors have pointed out, the section that imposes the liability, the section that my brother relies on for strict liability, specifically says, if an employer or person submits a bill, invoice, or a charge, those are distinct definitions, distinct terms that are undefined in the statute. If, as the appellant suggests, we're supposed to only look, the statute requires us to only look at the invoice, the legislature signaled that we're not only limited to an invoice because they include a very broad phrase, charge. We're looking at more.
But I think you lose if we have to go there, because the statute is incredibly protective of employees' tips. If you start messing around with terms like service, which we think goes to them, and gratuities, you lose. The only way you win is if it's absolutely clear that there's a division here. Isn't that right? Because again, this is not an employer-friendly statute. It's the opposite. If there's
Yes.
an error made and it's not clear, tie goes to the employee and you lose, right?
And yes, Your Honor, I think an excellent point here is that all of the cases dealing with this statute talk about situations where there's a possibility for confusion. The cases mentioned that a safe harbor provision was specifically included to dispel the possibility that a patron may not know whether a certain charge could be something that would go to the waitstaff. And importantly, Bednark and Cooney, our position is consistent with both of those cases. In Bednark, there was a contract.
Can you do Cooney for a second? Because Mr. Holtzman, and I can't find the sentence he's relying on, but it's probably there. But he's saying it was clear to everybody in Cooney, including the tip staff that they weren't going to get this. I don't know if that's true or not, but I'm assuming he's correct. So their confusion again went to the employee. Justice Lank, writing for the appeals court, says again, strict liability if you screw up. So how do you
Sure.
get around Cooney? Mhm.
Yes, Your Honor. Well, first of all, I think Cooney has some great principles that support our interpretation, but more importantly, Cooney was looking at an invoice that dealt with only one phrase, a service charge. There was no contract. I don't believe that there was a tip charged on top of or in addition to whatever that disputed fee would be. So the court said in Cooney, look, this is the situation that the statute is concerned with, a situation where you have the exact words that the statute uses, service charge, unaccompanied by anything else. And one quick point I would make on Cooney.
Although in Cooney, it is accompanied by one other thing, which is the employees are in the higher category. They're getting paid more because they have divisions between employees who can get tips and employees who can't, right? So there is some understanding in Cooney.
Yes.
Right. Okay.
And an important point on Cooney, and this is the part where the court is discussing what phrases or what terms could be something that would lead a patron to reasonably think it goes to the waitstaff. And they say tip and gratuity are synonymous. Common understanding is that those are for waitstaff employees. In the next sentence, they say, quote, in context, so is the term service charge. And Bednark also says, dealing with the administrative fee, unexplained in a contract, it specifically says, depending on the context and absent further explanation, a house fee could easily be understood as a tip or gratuity. Those factors are not present in our case. There is no question. And the context is exactly what the event contract says it is. So our position is consistent with all of the cases. I would like to point out the appellants and the dissent take issue with where and when the club communicated the safe harbor language to its employees. But the statute is not concerned with those questions. The case law makes clear that the statute is concerned only with whether the employer makes the designation a written description. And indeed, in Bednark, the court said use of the phrase designation being separate from a written description signals it can be verbal. And so to suggest that to be effective, a safe harbor communication needs to accompany some document in a transaction, I think is adding material limitations that the statute simply does not impose. It requires only that the communication be made. And I think that is even stronger in this case where we have a contract explaining it. There is no room for confusion. The amicus brief supplies some cases as support for its position, but in those cases, the numbers changed. They were not the same throughout. And I would acknowledge that.
Can I push you 1 second, Mr. King? Because say I think that, again, all ties go to the employees. All confusion goes to the employees. You have a pretty clear contract here, but you did make one error. Why do you still win with that error given? Because there is an error here, right? You know, it's not right. They goofed up at the end a little bit.
Yeah, there's certainly inconsistent labeling. And for that point, I would urge the court to look at the Masiello decision out of the Superior Court. I recognize it's not binding, but in that case, there was inconsistent labeling. But the court focused still on the fact that the employer made the necessary designation that dispelled the confusion. So I certainly understand and acknowledge that there is inconsistent labeling here, but I think it's important to point out the statute says that's not the end of the question. The statute says, what does that labeling mean in the context of the transaction you're looking at? And I think there can't be a
Don't we
Doesn't it
have
make
to-
more sense, though, to look at the final thing, which is the invoice, as opposed to saying, oh, I wonder what this, why not just look at what the invoice says? It says what it says. Why should we have to go back to the contract when this is the final word?
Sure. And that's a fair question, Your Honor. I think you have to go back to the contract and not stop at the invoice because nothing in the statute says to stop at the invoice. I think it pretty clearly says in multiple spots that I pointed out, it says, look beyond whatever a label might be, because that label may not tell the whole story. And we have cases that recognize that. I mean, Bednark specifically saying without further explanation. I would suggest that Bednark, in Bednark, the court was saying if that house fee had a designation in writing somewhere or verbally that clearly said what it was, I would suggest that that would be a different outcome in that case.
But Bednark, tell me if I'm wrong, Bednark doesn't use the term service charge.
Yes, that is fair, Your Honor. It's a different term, and I think our situation is also different. We don't use in isolation the term service charge. It's just not the same as CUNY, and it's an important distinction because it is consistent with what the contract laid out. There would have been no reason to split out separate charges. The 10% was the tip, and the 10% of the charge was for the house, and that is exactly what remained the same. And so if there are not any further questions from the court, I thank you for your time. I would ask that the court affirm the judgment of the Superior Court below. And thank you.
Thank you so much.